So yes, let's take the next defense. Okay, the next defense is necessity. Okay, so an act which will be otherwise tortuous. Okay, but because you have done that act due to some necessity. Okay, uh, it seems to be a defense here. But then like not all kinds of necessity will be acceptable. Okay, only certain kinds of necessity will be acceptable as a justification. And as you will see, as we discussed today, there are lots of theoretical and philosophical position on this as well. So one or two judgments from here and there will not conclusively tell you as to what will be the position of the court in some other cases, because the ideological position, the prevalent philosophical, theoretical, political, ideologies, all those things do matter on all these issues. Okay, now as you know, necessity, okay, it could be of two broad kinds. Okay, one is public necessity. Okay, the other one is this is absolutely nonsensical. The other one is private necessity. Okay, and then there is another kind. Okay, that's a little different in the sense that when assistance is given to a third party without their consent as a matter of necessity. Okay, we'll discuss all these three. So broadly we have two different. Okay, one is public necessity, the other one is private necessity. Now the thing is that there's this idea that you have certain rights. Okay, in all legal systems, certain rights that belong to you are recognized in those legal systems. Okay, and a violation of those rights, okay, if it fulfills the other definitional requirements, will constitute a tort. Okay, but there are certain situations, okay, in which due to certain necessity, such infringement of rights are excused. Okay, or can be considered as a matter of defense here. Okay, so the first one is public necessity. Okay, public necessity is like for the sake of the public. Okay, for the greater good of the public. Okay, so the maxim that we have is salus populi suprema lex. Okay, so essentially the idea is that your rights will otherwise be protected. Okay, so whatever rights these are. Okay, we have, for example, from natural law school, we come to this conclusion: you have right to property, you have liberties. Okay, you have right to life, etc., which are life, liberty, properties are protected. And quite often in legal systems, either through common law or through statutory laws or even through constitutional laws, protections are provided to all these different with regard to all these different rights. Okay, now usually you have protection of such rights. Okay, and no one can say that, well, there was a necessity because of which I trounced upon or infringed someone else's right. So it's normally not a justification, but there are certain situations, okay, when it could very much be a justification. Okay, so one is, as I said, okay, there's a maxim that goes by salus populi suprema lex. So not for every other reason will such infringement be justifiable. Okay, justified, but there could be certain situation where for the sake of public good it might be necessary. Now, for example, you live in a neighborhood and there's a fire in that locality. Okay, in one house there's a fire. Okay, now you have a portion of your building quite adjacent to that house. Okay, and then there's a whole lot of our other houses, okay, adjacent to yours. Now if no control is gained over that fire, then it will burn down the entire locality. Okay, so how do we stop it? If we, for example, take down a portion of the building which is immediately exposed to the fire, next house. Okay, in such case, to avoid such greater harm, okay, to the public in general there, okay, it is justifiable sometimes, not all the time. Okay, as this will depend on the fact situation. Okay, that a portion of the house is brought down so that what do you call it? To prevent greater harm. So that could be a defense, okay, in such a situation. So this private right is violated so as to protect certain other rights. Okay. Now, there are many other situations in which this could happen. Let me give you another example that will make it understandable to you. So, we fly. Okay, these days. Okay, um, and when you have boarded the plane, then there's this demonstration which is given, regarding what you are to do during emergency. Okay, and then you are told of all those things that you barely listen to. But then one thing, then that they tell you that in case of emergency, leave your luggage behind and vacate. Okay. Now, you know that, if your luggage is left behind, you have a right to, take your, luggage. But then in certain situations, you may not be allowed to, because why? Because if everyone carries luggage, then there'll be congestion at the door and more people will suffer, okay, maybe die. So in such situation, these authorities do have the power to compel you to leave your stuff behind and then, deboard the plane. So in such situation, okay, you may say that, well, that's my right, okay, but then there's a greater concern here that we have, of saving everyone else's lives, okay. So we have to prioritize lives, don't we? So there's a greater, harm that is to be averted, that we are to save as many lives as possible. So at the cost of little bit of your property, etc. So that is another example of a situation in which, necessity justifies infringement of certain kind of rights. Okay, so it becomes an excuse, a justification for such a tort. There could be other situations, okay, just like that, a ship on the sea, okay, in order to save the people there, it may be compelled to, throw off some property there, okay, that belongs to people, okay. So here in all these examples, you see that this is a clear case of, sacrificing individual rights for the greater good, okay. So that's why the maxim salus populi suprema lex. Now the question comes as to what extent even the government can infringe individual rights for the sake of certain collective for the sake of greater good. So that question is much more complicated than I'll be able to answer here in this context, in the sense that if you have certain entrenched rights in the constitution, then the court cannot really, the legislature cannot really, the state cannot take away those rights that easily as, for example, compared to other ordinary rights. So the entire debate on right to private property, as you have seen, the tussle that happened between the executive and the judiciary ultimately led to removal of that as a fundamental right from the constitution. Anyway, that's a separate debate. But the issue here is this, that even the state does not have, state, yeah, obviously, quite often it does things, for example, so as to, for the greater good. So, for example, land is acquired quite often, okay, so that high roads, the national highways are built, okay. In such case, obviously, you remember we had the other defense earlier, okay, so that has already covered it, okay. Now, the thing is that can state, for example, do certain things, okay, so maybe during war times it confiscates, okay, forcibly takes your property for the sake of, protecting the realm, okay. So it usually becomes a justification for that, okay, that, for the sake of protection of the realm, for the greater good, okay, the state is within its power to, occupy your property for the time being. So that's definitely there, but even with respect to that, the power is gradually, incrementally, that power is coming down, okay? So the justification is restricted to where it is authorized under a particular statute. So in England, earlier the, king or the queen used to have lots of prerogative powers, okay? Not statutory, but prerogative powers. But the recent trend has been that power is gradually being whittled down as the times change, okay. So there's an important case by the name Attorney General versus D. Kaiser's Hotel Limited. I'll just share a link with you guys. You can see it.
Sir?
Yes.
Sir, you gave the example of the ship accident, like there is some problem.
Mm-hmm.
And sir, can we apply inevitable accident too, because it was like a not exactly an act of God, but it was a force of nature which couldn't have, been prevented by the captain of the ship.
Yeah, obviously, but that's not really the issue. So we are not really dealing with whether the carrier, for example, is liable for the emergency landing. That's not the issue that we are at this moment dealing with. I'm focusing on that specific issue that you are not allowed to carry your luggage. Okay, so so for that you do not have to go all the way, to why the accident happened in first place. Okay, that will be another issue, huh? But on this issue I'm talking about, why you are not allowed to carry your backpack, okay, or your luggage, etc., whatever. Okay, that's because, well, you will create a congestion there, and then more people will not be able to get out. And yeah, so for that reason, although in normal situation they cannot say that you cannot take your property with you, but in those emergency situation, you don't even though it's your right in normal situation, in that situation it's not, and hence it's justified by the defense of necessity. Now, I understand why you asked, but that's a little different issue, as you can see. Okay, so for example, you're suing the carrier itself, that company itself for the emergency situation. Okay, maybe because it's because of some kind of negligence on the part of the do you call it? What the hell do you call it? The pilot, maybe, okay, or whatever, mismanagement on their part. In such case, maybe they can come up with that defense. Okay, but I'm just focusing on this instant issue. So is that fine, Shiva?
Excuse me, sir.
Yes, sir. I was actually asking about the ship example which you gave.
Yes.
So in the ship, like you said, it couldn't be saved. So that's where I was asking that if can we put in inevitable accident too.
Oh yes, the ship case. Yeah, you can. I mean, if the reason, the situation suggests that, okay, it has happened because of such an incident. Okay, which is, you can have multiple defenses. You need not have to restrict yourself to only that. So whether the accident was due to negligence of the whosoever was in charge, okay, the captain, whatever. If that's your allegation, that's the allegation that you are making, they may come up with the excuse that, well, it's not because of our fault, but maybe we have been hit by an object that we could not have detected using reasonable care, etc., etc. So obviously that defense is there. But why were your objects thrown off? And then you can say that, well, I have a right to property with respect to this, okay? Then why, and that right has been, violated. But then their defense will be that, well, if we hadn't thrown it off, then the ship would have sunk, okay? So to avoid that, greater harm, to save lives, okay, we had to throw off. Imagine the Titanic situation when they were trying to, deboard all the people into the boats, okay? If someone said that, well, I also want to take my property with me, okay, the same defense, okay, even in that situation could be thought of. So I hope you understood. In both the cases, there is this subtle difference that I was trying to point to you. Is that fine, Shiva?
Excuse me, sir.
Yes, sir. Got it. Thank you so much, sir.
Yes, Vishwajit, tell me.
Sir, I have two doubts.
Yeah, tell me.
What you asked, sir.
Yes.
Sir, what if the situation arises from the negligence of the defendant himself? Is the necessity defend is acceptable? And second doubt is, sir.
No.
Sir, what if harm done is more than harm prevent? Then is the defense available?
Very good questions. Okay, I think both the questions are very limited. Vishwajit puts it very aptly. Okay, the defense is not applicable if the defendant's own negligence here creates the necessity in the first place. Okay, that, well, you cannot say that, well, yeah, for necessity, okay, we had to do this, so we deny you your right now, so you cannot claim for the violation of your right. That you cannot say so. If the defendant's own negligence had created the situation in the first place. So for example, the flight, okay, as he was pointing out, or in the case of the ship, as both of you have rightly pointed out, if the very, negligent, control of the ship had led to such an emergency situation in which they were then compelled to throw off your belongings, then they cannot say that, well, necessity. No, definitely not. Law will not be that generous. Okay, it's all about, see, the questions of morality, so much related here. Okay, principles which are so much related here. In fact, later on in jurisprudence, when we study, some philosophers say that, okay, legal systems are not merely about rules as you find in statute books, but also principles. So you see clearly the principles which are here. Okay, law always has a certain underlying network of principles. So obviously, while the judge comes to that decision, both of you have very aptly pointed this out, that yes, if the situation situation is the creation of the defendant itself, then they cannot further say that, well, out of necessity, we had to throw off your belongings. So definitely not. That's the one question that I understood that Bishwajit had asked. What's your other question here, Bishwajit?
Yes, sir. Sir, what in the case of if the harm done is more than the harm prevented, then
yes, that we will discuss in a while. Okay. Now the thing is that here's the thing. Okay, in difficult situations, okay, it's this factors, okay, this fact situations the court has to take into consideration. Okay, so when these situations arise, okay, let's assume that this is not one of those situations created due to negligence of the defendant. Okay, let's assume that this is purely, not due to negligence. Now, for example, there's a fire. How much portion of the building is to be brought down? So if we could bring down only a part of, if we bring down only a part of the building so as to prevent the fire, then fine, okay. But you need not take down the entire property. You don't need to, okay. So if someone deliberately does that, so obviously court will take those facts into consideration. However, no one can do perfect calculation that this is the amount to which I'll be infringing your rights. Okay, no one can make that exact calculation. So some kind of leeway has to be given to these parties. Okay, so yes, court will look into those specific fact situations to, for example, derive. Now let's take the example of the ship. Okay, if they could just drop a few boxes, large boxes, okay, and then save life, fine. But if they threw everything without that being the requirement in that case, okay, then obviously you can say that, well, yeah, they did not exercise their judgment well enough. Okay, so all those facts will definitely be taken into consideration by the court to come to the right conclusion. But the principle is quite clear here, isn't it? That yes, necessity could be justification. Is that okay now? Both Shivang and Vishwajit? Okay.
Yes, I got it. Thank you, sir.
Okay. So, but then you go do your research. As I told you, I'm teaching this subject for the first time. So while I explain things, I'm trying my best, but maybe I'm missing out on something that you can point out to me later on. So it's fine. Okay. But this is what my understanding of the situation is. So yes, I hope, and these are very good points that you have raised. Okay. So defendant's negligence, due to defendant's negligence, if the situation arises, then later on they claim the justification of necessity. That's not acceptable. So that's a very good point that you have raised. And yeah, I was talking about whether the state. So for example, in the case of England, okay, the trend has been this, that with the passing of time, your acts can be justified only if it is in accordance with a statute. And that statute can be justified only if it is not in violation of fundamental rights as are guaranteed to you in the Constitution, okay, to the extent that they are entrenched in the Constitution. But in certain cases, for example, in England, the Queen or the King or the Crown essentially has certain prerogative powers. These prerogative powers are not from the statutes, okay. Those are historically the powers that the Crown actually exercised, okay? And some remnants of those powers are still there, but increasingly being whittled down, okay? So I shared a case with you, if you guys can see this, okay? You guys can go and read that case, okay? So this is a very important case, okay? It's essentially considered the principles on which, courts decide whether a statute statute has, what do you call it here, fettered prerogative power. So you can also see this same thing in Wikipedia, not for the sake of our do not cite from Wikipedia in the examination, but these are the links which I can share at this point of time. If I could scan books, I'll send you, but I can't do that, so I'm using all these links. Okay, so circumstances in which statutes can operate to fetter prerogative powers. Okay, so anyway, what was the outcome of this judgment is that it decided that royal prerogative does not entitle the crown to take possessions of subjects' land or buildings for administrative purpose connected with the defense of the realm without paying compensation. So that's what is essential for us. Okay, so even for the sake of defense of the realm, it is not within the royal prerogative power to to first acquire your property for the said purpose and not pay you compensation, if that is a requirement under a statute. So if that is a requirement under the statute, then prerogative power cannot be taken up as a justification for not providing you the compensation. So what does that tell us? In case of England, at least, the idea is that private property is respected much more than the prerogative power that the crown holds. Okay, so yeah, that's essentially broadly the idea. In India as well, okay, private property, even though it's no longer considered as a fundamental right, but nonetheless it has its sanctity. So when under, for example, certain act, okay, if your land is acquired, the state provides you compensation. Okay, anyway, those things you will discuss in constitutional law later on. If we go beyond this, then it will be problematic. We'll not be able to complete this. But I hope you understood the issue here. Have you any other confusions that you might have? I hope you guys understood. Any difficulties? Any queries?
No, sir.
Okay. So another necessity that we discussed is private necessity. Okay. So in all these cases, as you see, okay, these were examples in which private rights were justifiably infringed for the sake of public good. Okay. Now, could the same be justified for the sake of private benefit? Okay. Much less than it is justifiable for the private, So some examples, okay, but then this is a very difficult question to answer, so I will just leave the debate up to you, okay? It's this, that, let me give you an example. So, maybe you're walking on the road, okay, and then you see there's an oncoming car, okay, veering off the road and you're on the pavement. It might hit you unless you enter someone's property, okay? In such situation, you entered the property so as to avoid being, collide with the car. Okay, so you are prohibited from entering someone's, property. But then you trespassed in this situation by entering into their property. Will that be an acceptable, justification? Say yes or no.
Sir, because
yes, sir. It will be
to avoid greater harm, you can.
Okay.
Sir, because it does greater harm.
Yes, so it was your necessity. To save your life, you had to enter that you otherwise wouldn't. Isn't it? As simple as that. But then let me give you another example. Okay. You were so hungry, you haven't eaten in like a few days, 3-4 days, you have not eaten, you were hungry. And then you see that there's a nice shop that has displayed, beautifully baked, bread and other food stuff. So you're hungry, but you don't have the money or you don't have the food. Okay, so to save yourself, you go and steal a loaf of bread from there. Okay, would your action be justified?
Sir, isn't this a very philosophical question?
Exactly. It's a philosophical question, but I still want answers from you.
Sir, my moral self would allow it, but my legal self would not.
Yeah, so that's the thing, okay, that's the thing. But it's not that clear either, okay, it's not that clear either that we do not have a clearly laid down distinction between where legality ends and where the question of morality, begins, okay. So, yeah, so if we say that, okay, here's the thing, okay, you are very much correct in saying that, yes, that cannot be the justification. So, for example, if someone is homeless, will that person have a justification to enter your house and then stay there? Obviously, that's not the case. Okay, private property is protected even when someone else has a necessity. Okay, law does not give such protection. Okay, give such excuse to others. Okay, to encroach into someone else's property because they have this overriding necessity. However, to what extent should we be willing to not engage with these philosophical questions is a question that is moot, okay, especially in constitutional law, okay, that we say that necessity is not justification for infringing someone else's rights, okay, and never, okay, but then let me make this clear, okay, so maybe you can say that in individual situations, okay, one has a right, okay, which is protected as against others infringement, but then at the same time it is also necessary that states provide certain kind of protection to individuals so that they do not end up in such situations. So those mitigating factors should definitely be taken into consideration. Why? So even though it's not an absolute defense, but my personal position will be this, that courts have to nonetheless take this matters into consideration. So we have such cases, okay. So for example, the Pavement dwellers case, okay, which is very famous, okay, by the name Olga Tellis versus BMC, 1985, where some encroachers, okay, some pavement dwellers had occupied a portion of the pavements, okay, which is public property, okay. So even then, it's not the first kind, as you know. So we're considering state as the person here, okay. So here, these pavement dwellers had infringed certain rights, okay, belong to the state, okay. Now, would this be justified or not, okay? So obviously in that case, as you know, although this right of pavement dwellers, okay, was recognized, okay, but then in reality they were eventually asked to be evicted, okay. But certain important observations were made which are very important for us, okay. So the court had observed, okay, that under the law of torts, necessity is a plausible defense which enables a person to escape liability on the ground that acts complained of are necessary to prevent greater damage, okay, inter alia, to himself. Here, as elsewhere, in the law of torts, a balance has to be struck between competing sets of values. So even court will not tell you, okay, that, well, you are helpless, okay. So it's a moral predicament that the court has to face and decide ultimately. And sometimes they have given very encouraging judgment. Sometimes they haven't, okay. So there are many such cases that you will come across, but I will not go beyond this because this is a moral question. So for you tomorrow who are going to be present, so you see what is the importance of these moral questions here, okay. If you were a judge, you have to decide on all these matters. There is another important remark which has been made by Lord Denning, okay. He says, if homelessness were once admitted as a defense of trespass, no one's house could be safe, so the court must, for the sake of law and order, take firm stand, okay. They must refuse to admit the plea of necessity to the hungry and the homeless, and trust that their distress will be relieved by the charitable and the good, okay. So a very important remark which has been made by Lord Denning, that, well, those who are hungry. Now imagine, okay, let me make it a little more difficult for you, okay. Someone, okay, a mother who has not been able to feed her little baby, okay, since she has been born, okay, the baby is crying, emaciated, no food, will die maybe in a couple of hours if no baby food is given to the baby. And then imagine there is baby food in a shop, the mother steals and feeds her baby. What will the law say then? What do you think the law should say then?
So the law will hold her liable.
Yeah, so here's the thing, okay, but let me say this, okay, that should not be the case is what I'm saying. So that's what was the remark made, that in such situation, the court has to decide keeping in mind all these other factors. It cannot be as blind as what Lord Denning is talking about. That will be a morally barren, morally, bankrupt society we will be living in. Okay, so yes, let me tell you, we need to strike a balance here. Okay, it should not be black and white, nor should law also be black and white in such situation. As a society, we need to empathize more with the sufferings of others. Okay, many times many people will tell you that, well, it's because of their own mistake, but that's nonsense. Let me tell you, quite often it is not. Okay, many times, what's the mistake of the baby that she is suffering? Okay, obviously she hasn't done anything to be deserving such a situation. So in such case, even the state has some responsibility so as to protect. Okay, but to what extent should we be able to make individuals liable in such situation? So that's the question that has been addressed by Lord Denny, who's saying that let's leave it to charity, okay, of individuals. Okay, whether they want to be benevolent, whether they want to be generous or not, and not impose it upon them. Obviously, that even that position is also based on certain political theory. Maybe laissez-faire, maybe private property, maybe libertarianism. But then you have the other view as well, that no one should be dying because of such situation. In such case, even if they infringe someone else's private property, the law should take into consideration those mitigating factors. That's what my position is. Okay, so do you get it? Do you understand it? We don't want to live in a morally degenerate, morally bankrupt society. You don't want to. You see, most of the progressive countries in the world have some kind of social security program, so that no one falls below the safety net. That one feels the necessity to then go and enter someone else's house. Okay, and in those societies where such protections are not given, where such safety nets are not provided, you see more crimes. Okay, you see more inequality, you see more problematic and divided society they are. Look at United States, one of the most prosperous countries, but also one of the most unequal countries. India is on its way to becoming, already it's very unequal, but it's on the way to becoming an unbearably unequal society, which it should not. Okay, some set of basic minimum protection should be there. Anyway, those are separate discussions, but I hope I have addressed the question here. Okay, now the third kind of necessity is like assistance given to a third person without his consent as a matter of necessity. Now, for example, if someone has met with an accident, okay, is unconscious, lying by the road, okay, and that person is taken to hospital, that person is in no situation to give consent to the treatment that he will be provided, but then that person is provided treatment. Okay, while that treatment is being provided, certain rights are obviously possibly infringed. Okay, but in such situation, this defense will work, that assistance has been given to a third person, okay, without his consent, but this was a matter of necessity. That person was not in a situation to consent to such treatment, so out of that, this treatment has been done. So is this clear? I hope necessity is clear to all of you.
Yes, sir.
It's just gets difficult. If I want to complete a topic well, then we do not have much time. So I'll just complete the remaining topics, okay, as quickly as possible. The next justification is private defense. Okay, private defense, what does it mean? So so as you know, we will study later on in jurisprudence that you have certain rights. Okay, you have, for example, right to your life, okay, to your bodily integrity, okay, right to your liberty, right to your property. Okay, now state is there, okay, it has this entire machinery put in place to protect your life, liberty, property. Okay, it has police, it has many other such institutions to protect all that. Okay, court system and so many things. Okay, but as you know, when there is a threat to either your life or your property, you don't wait until the police arrives and then saves you, do you? You don't, because by then your rights would have been harmed. So in such case, law recognizes your right to defend your own life, liberty, property. So that's essentially what private defense is all about. Okay, but the question is that in order to defend yourself, you might need to hit, okay, you might need to push someone back. Okay, but then to what extent are you allowed to exercise force in such situation? So the understanding in such situation is that reasonable force which you believe is to be necessary has to be exercised. Okay, now for example, a guy who has come to just was having a heated argument with you, and you felt that okay, that person is going to harm you, you pull out the knife or you pull out the gun and shoot that person. Do you think that's a reasonable force that you have exercised in the light of this limited facts?
No.
So yeah, it could be different. It could be like one of those hues, like mountain from Game of Thrones. Yeah, you can just twist your head, and yeah. So all those situations will define what kind of dangers you are in, but what kind of defense that you exercise will be determined by the fact situation. Okay, so it has been said, okay, in one case by the name anonymous case, okay, it was said, and the situation was when a man strikes at another within a distance capable of the latter being struck, okay, nature wants the party struck to resist it, and he is justified in using such a degree of force as will prevent repetition. So here's the thing, okay, so the defense is not supposed to be the other one is just punching you and you are merely defending yourself. Okay, so maybe if you just knock that guy out, maybe that person will stop hitting you. So it's not just you have to just use the shield, you can also use the force to knock that person down, but then it has to be reasonable. You cannot you should not end up killing that person, okay, unless that is what is necessary. Unless that person, for example, is pointing a gun at you, then you might be justifying fighting, taking that person down as well. So each fact situation will determine what will be the reasonable force that is necessary in that instant. So I hope this is clear to you.
Sir,
Yes.
if the man pointing a gun at me is holding a fake gun,
Sorry.
but if the man pointing a gun at me is holding a fake gun, but according to me it's a real gun because that's how he's acting, and if I end up putting him down, so would I?
So it depends. It depends. Like if it looks exactly like a real gun, okay, it does not look like a toy gun. Obviously, in that situation, okay, a child, okay, comes and does few at you, okay, and then in that case you cannot say that. Well, I was worried that I will be hit, so I ended up killing. But then, so the fact situation will matter, okay. If it resembles something so real and you were under imminent threat that okay you will be killed, then you are also justified in taking whatever is necessary to prevent yourself. So I would say that let's rather live in a society in which there are fewer guns to point at you. Because why am I saying this? Because look at America, okay, they have this gun right, stupid gun right that they have, okay, and then people get to keep it, okay, and then lots of people are killed by police because they put their hands in their pocket, okay, maybe to bring out something, some handkerchief or something, but the police say that they were under threat, okay, they were under the fear that they were getting their gun to shoot at them, and then they end up killing them, okay. So many cases that you come across, and that becomes a justification as you have seen, okay. And then you have heard about so many cases in which blacks are specially targeted, okay. So let's so let's say that let's not live in such a society in which there are more guns in people's hands, okay. That's what, and obviously to answer your question, it's simply this, that it depends on what does it appear like. All those facts will be taken into consideration. Yes, I think Samriddhi had something to say.
So what about police brutality? Sometimes what happens that in a mob, innocent people are also involved.
Yeah, so police brutality is never justified, like especially in the custodial torture is prescribed. But if you're talking about what they do, for example, during protests, okay, obviously if police should not be having this power to harm people, okay, only to the extent that it is necessary to prevent chaos and breakdown of law and order. But quite often you see that they go much beyond that and end up hurting people, okay. So then again, this thing will depend on where you are. In India, you see police kind of get away with absolute brutality, absolute absolutely uncivilized behavior, because they have the support of those who are in position of power. At the end of the day, who has to file the charge sheet. Okay, then all these things are in the power within the power of the executive. Okay, so I'm just talking about the criminal aspect of it. Okay, in civil matters, only God knows. Okay, so yeah, that's what it is. Okay, so yeah, but if you are living in a better country, then obviously you will have your rights will definitely be protected. Okay, so it depends where you are, but yeah, obviously police does not have the authority to beat you up or kill you just like that. Okay, they should definitely use restricted force, but yeah, we do not live in such a good society. But then I'm not saying that that's justified. It definitely should not be justified, especially in case of peaceful protest. Okay, is that okay, Samriddhi?
Yes, sir.
Huh?
Yes, sir. Yes.
Okay.
Thank you, sir.
So yes.
Sir, the burden to prove private defense on whom in the court?
See, the burden will be definitely, so, you are taken to court, okay, so you are the defendant, okay, you are the defendant, and you have to say that, well, what I did, my action was completely in self-defense. The other party obviously has already said that, okay, you have violated that person's rights, okay. Now you are saying that, well, it was done in self-defense, so obviously you have to prove that it was done in self-defense.
Okay, sir.
Okay. Okay, so the next one. Okay.
Sir?
Yes. Sanskriti.
Sir, I was asking about the syllabus, sir. I think you're not done with the topic, so I'll ask in the last.
Yeah. Let's not start that now. Okay, so let's complete this. As I said to your teacher, I'll just complete the topic and then get back to. So I hope you understand. Now another situation. Let me talk about. Okay, so someone who came towards you, pushed you, and then started running away from you because of the fear that you will also react. Okay, and then you find your gun. Okay, pull out your gun and then hit the person who was running away. Okay, in such case, the self-defense will not be acceptable as a justification. So there's a case of a dog. Okay, so a dog that had attacked a person and then seized the attack and then just started running away, but the person just pulled a gun anyway and then shot the dog as it was running away. Okay, so it was held that the defendant was not justified in doing so. To justify shooting the dog, he must actually be attacking the party at the time. Okay, so that was what was held in the case by the name Morris versus Nugent. Okay, I'll type it. However, as you know, it will depend on the specific fact situations. Okay, this is the case. So we have just two more that I will quickly finish and then you guys can go. I have taken more than an hour's time. Yes.
Sir, if two persons are fighting on a street and one person is hitting the other who is unable to defend himself and some other person...
others also have the right to defend. Someone who's vulnerable, for example, is not able to. If a little boy is being abducted or being beat up, you have the right to save them as well. It's not just yours, but also of others. Even others' property, you can use the defense. Quickly, and then I'll let you go. Okay. Another is yeah.
A while ago, you said that in order to prevent an accident, you veer into someone's personal property.
Yes.
So that is justified.
Yeah.
So in this situation, I am entering someone's house and drive over someone's leg or body.
Okay.
So would that defense of necessity still be applicable? Because I have ended up doing more harm than I have prevented.
See, the answer is never, black and white, this or that. Okay. The court always has to do in the light of these fact situations, the kind of, calculations. I'm giving you a situation, okay, very important moral, question that we come across. I wish I had this next class as well, but your history teacher is probably waiting and I have eaten into that. But let me complete this, let her take the rest of the class, okay. So, yeah. So, we have this trolley problem, okay. Why am I talking about this? But it's related. So, imagine, okay, there's a trolley, okay, on a track, okay, coming. and you see that there's one person, okay, and there's a diversion, okay, and there's a pulley lever that you can pull or push so as to divert the direction of the trolley. Now you are there next to that that lever, okay. Now you see that oncoming trolley, and then you see that it could go in two directions. In one direction in which the trolley would go, there are 5 workers who are working, okay, but there is another almost empty track except for one person who's there, okay. Now if you do not pull the trolley, it will go straight and kill 5 person, but if you pull the trolley, then it will go and kill 1 person, okay. Now what will you do? I'm just introducing this to you. I'm not going to wait for your answer because I do not have much time. But yeah, so you have 2 choices, okay? And in either of the case, we have reasons for choosing one over the other, okay? We will discuss about this later on. But what I wanted to tell you is that when you decide on all such things, okay, you have to do some kind of calculation, okay, some kind of moral calculation you have to do. So for example, if you were a driver, okay, if you're a bus driver, and then you see that there are 5 people on the road, okay, if you do not swerve your bus, then you end up killing 5 people. But if you just take a turn, then you end up killing 1 person, okay. There is a choice here, don't you think? There is a choice here. So you have to take certain decisions in the light of that situation, okay. So calculations are done. So for example, in order to save your life, you thought that maybe I can save my life at the cost of someone else's, a little bit of injury to someone else. So those facts I don't think court will be ignorant of while deciding a particular case. Is that fine? Sohail, I think, yeah. So the answer is never black and white. Okay, the answer is never either this or that. Okay, that's a fallacy we fall into, that either this or that. I think there are many possibilities in between, and all those factors will definitely be taken into consideration by the court. Okay, so I hope I was able to answer that. I have one more question. So can we compare that village case to something like it is euthanasia, but then euthanasia is a little different, because see, in this particular case, so far as I could understand from the facts, the girl never said that, well, kill me. I think the girl very much has her own agency, okay. Her father, please say kill me so as to prevent, to protect my honor. Obviously that's not what the daughter is saying. But then in case of euthanasia, if someone is like in a vegetative state, okay, in such case, that person is not able to say it, decide it for himself or herself, okay. So in that situation, others have to decide, okay, on behalf of that person. So there is a difference here. But then that's a different moral question, and moral answers again cannot be black and white, okay. There are many different possibilities, and I think I will leave this question of euthanasia and all that for appropriate time and place when we were going to discuss. So anyway, I hope, I might be wrong, okay, I very much accept it, but I'm trying within my capacity to, answer your questions. So I hope I made sense. Did I, so far?
Yes, sir.
Okay, yeah, if you have better answer, you feel free to, bring it here. Always welcome. So, yeah, so I'll take the next 2 and quickly let you go. Okay, so the next one is plaintiff, the wrongdoer. Okay, the defense is that, well, the plaintiff, said that, well, the defendant has done this to me, or infringed my right. So, yes, I need to be compensated. Okay, then the defendant says that, well, you are the wrongdoer. Okay. That becomes a defense, okay. It is a justified defense. But here's the thing, okay, not really. We need to make this distinction here. Obviously, if plaintiff is the wrongdoer, it becomes a defense, okay. But to what extent, okay? Now imagine a situation, okay, 2 persons collude, okay, they conspire together, okay, so as to burgle, enter someone else's property and commit burglary, okay. So that's definitely a wrong thing that they are doing, okay, that they're doing, okay. Now while they are on their way to commit this crime, what happens is that one of the partners in crime steals the other's the wallet. Now, as the person whose wallet has been taken, okay, takes the other person to the court, okay, and then the defense here is that, well, you were committing a crime with me. Will that be a defense in such case? Can you answer? Did I make sense? Okay, was I able to explain this?
Yes, sir.
Huh? So I'll say this again, okay, explain it in simpler words. So for example, A and B want to commit burglary in C's house, okay, while A and B were on their way, okay, together they conspired. Now they were on their way. A takes B's wallet without his consent, so steals B's wallet, okay. Now B takes A to court that, well, you have done this, okay, so I need to be compensated, okay. So in such case, can A say that, well, you were committing a crime, you were on your way to commit a crime, okay? So would that be a defense? As I said, okay, the idea is that plaintiff the wrongdoer. Will that be a sufficient defense in such case?
No, sir.
Why not?
Sir, I think that in this case, B will get defense.
B is the complainant here. I mean, as you can see, B is the plaintiff here. So B is not defending. A is defending, saying that, okay, you were with me in committing a crime. So will A's defense that, okay, B was also a wrongdoer work here?
Sir, A will not get the defense of.
So why is that? Why is that?
Because sir, in this case there is no relation to.
Exactly. Very good. So see, law is easy. Law is about, like, not that easy all the time, but yeah, most of the time it is quite simple for us to understand. Yes, if they were on their way to commit some crime, they haven't, and that's a separate issue altogether, isn't it? We are concerned about whether B's defense will stand as against A. Okay, obviously not, because it's not related to them committing burglary, which is different. Okay, so once you commit a crime does not mean that your other rights also cease to exist. Okay, and in this particular case they haven't even done that. Okay, so I hope you understood. Okay, now if the harm that you have suffered, okay, itself is because you have committed the wrong, then it's a different situation. So it says a plaintiff is not disabled from recovering by reason of being himself a wrongdoer unless some unlawful act or conduct of his own part is connected with the harm suffered by him as a part of the transaction. So it has to be part of the same transaction in which you have suffered, that too because of your own wrongdoing. Okay, only in those situations will this defense be applicable and not otherwise. Okay, so but even then there are certain restrictions to the kind of harm that you can cause. Okay, the kind of harm that you can cause to someone who has been a wrongdoer. So you remember the other day we had discussed about this case by the name Bird versus Holbrook, okay, in which the plaintiff, who's the trespasser, had gone across the fence, okay, to get a fowl, a pheasant that he was chasing, and while doing so he is struck by a spring gun, and then when the matter goes to court, defendant says that, well, you trespassed into my property, so you are the wrongdoer, okay, the blame is on you, so you have I'm not to be blamed for this. Okay, so in such case, you remember what was decided by the in that situation. So you haven't given the other side the notice that, well, there are dangers involved here. Okay, so whenever someone commits a wrong, does not mean that he or she loses all the rights. No, definitely not. But unless what happens to you is solely because of you in that situation, obviously, yeah, that defense can be taken. So yes, that's what this maxim is all about. Okay, so this is based on a maxim which you will be taught again. Okay, that is known as ex turpi causa non oritur actio. Okay, ex turpi causa non oritur actio. Okay, from a wrong cause, okay, no action, lies. Okay, so that's essentially what it says. Okay, so yes, your conduct will definitely matter. Okay, even in law of equity, we have certain maxims, okay, which are more or less related to this. So which says that he who comes to court must come with a clean hand. Okay, if you go to the court seeking protection of your rights, you must come with a clean hand. Okay, so plaintiff should not be the wrongdoer. But then, as I said, the wrongdoing has to have some relation. It should not be completely disconnected. So I'll take one last one and then let you go so that you guys are able to attend the other class. Okay, so the last one is acts causing slight harm. Okay, acts causing slight harm. So for example, you go to Indian train stations, or for that matter even airports or the market space where it's crowded, thronged with people. Okay, there's no space. Okay, and quite often while you are moving, you end up hitting someone. Okay, not like hitting, punching, but end up shoving someone unwillingly. Okay, involuntarily, it just happens. Okay, so you end up harming someone, but you didn't really want to harm that person, and it's very minimum infringement. Although it's the infringement of right, you have trespassed someone's body, but then it's very minimum. Okay, so would court recognize a cause of action in such case? Well, there's a maxim that says de minimis non curat lex. I'll type it. Okay, so here's the maxim that says de minimis non curat lex, which means the law does not take account of trifles. Okay, so small matters. Okay, just get on with your life. Okay, just consider a little bit of mistakes here and there. Because we are not perfect beings. Okay, we are not gods. Okay, so we are not perfect. God has created this world. I don't believe in one such God, but if at all such God exists, look at the kind of mess that the God supposedly perfect being has caused. Okay, created in this world. So obviously we, the lesser beings, are bound to make mistakes here and there now and then. Okay, so if every such mistake were to be taken account of by the court, well, then all the best. So it does not happen, nor will the court have the wherewithal, the capacity to deal with every such issue. So what it will do is that minimum, when there is a slight harm, the court will ignore such cases. Okay, however, you have to be very chary, very cautious about this. Okay, so for example, if you have a landed property, someone walks across your landed property, that in itself seems to be a very slight harm. Okay, well, what really happens if I have a vacant land? Okay, I'm not doing anything there. Someone walks across. That seems to be a slight harm. But as if someone else, your right, if your right remains dormant, okay, and someone uses that right to your detriment, after a certain period of time, you lose that right. Okay, so for example, if someone walks across your land for 20 years, after that person gets the right to walk across your land. So if you have, a right to collect fruits from somewhere and someone else does it for a certain, for 20 years, then that person can also get such rights. Okay, so we'll discuss about all that later on. So in those situations, even though single infringement seems to be very minor, but the effect of it over a period of time could be very dangerous, to the extent that the person who has the property ends up losing certain rights. Okay, so in those cases, again, although the single infringement seems to be minimal, even then you will have a remedy. But of the other kinds, so for example, while walking on the street, okay, you just end up touching someone else's shoulder, okay, and because there's little space, okay, obviously in those situations, okay, or for example, you sneeze and someone else feels threatened, okay, obviously not all those things will not be taken into consideration by the court. So that's another defense known as acts that cause slight harm. Also the maxim known as which is applicable here is de minimis non curat lex. Okay, so I hope that's clear. So with that, I have completed all the justifications. Next we will take up specific torts from the next class onwards. So if you have any issues, quickly ask me, and